Welcome, everyone. We will get started. This is...
Point of order.
Yes, Mr. Carrick.
Sorry, I just wanted to express my appreciation to the clerk for once again getting a televised room. I know they're in short supply on the Hill, but I wanted to express my appreciation to the clerk and all those who work hard to make sure we can be held accountable to the highest extent within our parliamentary duties. Thank you.
Thank you, Mr. Kirk. Mr. Angus.
Thank you, Madam Chair. I wanted to bring this up because I was very uncomfortable about a tweet that you sent out regarding a vote by one of the members. I voted with the Conservatives because I believe that this ethics issue deserved to be heard, but it was voted down, and it's voted down because of the right of every member to vote according to how they see the issue. I think it's vital that we have trust in the chair to be nonpartisan. The chair has to have our support. I have to know that when you rule against me, that you were doing it because you were the chair, not because of a particular interest. And I think that this tweet is very unprecedented, and I'm concerned it was an attempt to intimidate a member of our committee, and I think we need to address this, and I would hope you would be willing to address it as well.
Sure. Mr. Angus, thank you very much. There was no tweet, for the record. However, there was a Facebook post. And I will take full responsibility for that. I did, in fact, post something with regards to the member from the Bloc Québécois. And so to her, I will apologize. As chair, it was a misstep. And I certainly apologize, and then it has been taken down. So with that, we will go on to hear from our witness today, which, of course, is Ms. Maynard. Who serves as our witness for the next hour. And so you have 10 minutes to open with remarks, and then we'll proceed with questions from the members.
Thank you, merci.
Thank you.
Merci, Madame la Présidente. So thank you for inviting me here today. Merci beaucoup de m'avoir invité aujourd'hui.
Thank you for inviting me here today, and I'm pleased to be able to speak to you about my role and to meet many of you for the first time. I have been the Information Commissioner of Canada since March 2018. With 2 years under my belt, I feel that I'm in a good position to provide some perspective on my mandate and offer you some insight as to what's on the horizon. I expect that your analysts have already provided you with an overview of the mandates of the agents of Parliament relevant to your committee, so I'll speak briefly on my mandate in my office, followed by my priorities. I'll then touch on some of the changes that have been front and centre at the OIC, as well as some of the challenges we face as an organisation.
Point and a frequent source of confusion. The overall administration of the Access to Information Act and the policy instruments and tools that support its administration all fall under the authority of the Treasury Board Secretariat. This means that TBS is overseeing the handling of access to information requests within the federal institutions. My role is to investigate complaints relating to these requests, normally because the institution is late in responding or because requesters are not satisfied that they have received all the information that they are entitled to. While my office receives thousands of those complaints a year, I have also the power to initiate a complaint myself. In addition, I can initiate and intervene in court proceedings when it's necessary. My office has done this a couple of times. As an agent of Parliament, I report annually on my activities, and I can also issue special reports to Parliament in respect of important issues that fall within my powers and functions. Le commissariat compte 120 employés environ.
My organisation is made up of approximately 120 employees, with about 70% of them working on investigations. I'm supported by 3 deputy commissioners, one responsible for investigations, one at corporate services, and legal service and public affairs deputy commissioner. My goal is to maximise compliance with the Act using the full range of tools and powers at my disposal.
Is of critical importance because Canada's Freedom of Information legislation gives Canadians the right to access information about their government, about the activities it undertakes, the decision it makes, and the money it spends. The Supreme Court of Canada has called this right of access a quasi-constitutional right. You won't be surprised to hear that Canadians are submitting more and more requests because they want to know how decisions in governments are made and how the government is using public funds. This knowledge promotes trust in our institutions and in their leaders. I can attest that the thirst for this knowledge will not be going away. I would now like to speak to you briefly about my 4 priorities, which have been the focus of the first 2 years of my mandate. They form the basis of my soon-to-be launched strategic plan, which will carry me through the rest of my 7-year term. My first priority is to optimize openness and transparency within my own organization. One of the ways that we've done this is by publishing guidance regarding our investigations so that complainants can understand how and why we are reaching certain conclusions. We now have a searchable database of decisions as well. Both the database and the guidance documents are available on our website. Une autre de mes priorités est de favoriser.
Another priority for me has been to foster collaboration with stakeholders. With complainants specifically, I have worked diligently on ensuring timely communications, gaining a better understanding of their needs and what they are seeking, and ensuring better follow-up on their files. We have made some progress, but we have a long way to go.
I also meet regularly with the federal access community. These are the public servants who process requests within federal institutions subject to the Act. I consult with them and encourage them to flag issues and present new ideas for innovation. In addition, I meet regularly with the heads of institutions and their senior management teams. I let them know what is working and what is not working in their approaches to managing access requests. My third priority has been to implement recent changes to the Access to Information Act. The Act came into force in 1983. Amendments passed by Parliament last June included important modifications. These amendments gave me additional tools. For example, I now have order-making powers. This means that I can order an institution to take specific actions, including disclosing more records, when I find that the complaint is well-founded. I can publish these orders and my recommendations in all of my final reports on my website. In fact, the first final report was published just last week. Institutions can also now seek my permission to decline to respond to a request that is vexatious, made in bad faith, or otherwise an abuse of the right of access. As the bar for approving these type of application is high, I have granted it only once to date. Last, but certainly not least, it has been my priority to tackle my office's inventory of active complaints. The inventory has proven to be quite a challenge. Even though we are closing more files and are reducing the inventory of old complaints, there has been a marked increase in new complaints. By this time last year, we had received about 2,200 complaints. This year, so far, we have registered 5,900 new complaints. Importantly, while we have closed more than double the number of files this year, our inventory keeps increasing rapidly. This leads me to another significant challenge facing the OIC, our funding. We are grateful for the $1.7 million we received when the amendments to the Act came into force in June. But every year, for the last 4 years, the former commissioner and I have had to ask for more funding to deal with an ever-increasing workload for our investigators. While temporary funding has been helpful, it has also resulted in a staffing challenge for my office, as we're not able to offer permanent jobs. We find that we invest resources into training new recruits and hiring consultants, only to lose them to offer of more permanent positions elsewhere. It makes the planning difficult and sustaining a momentum impossible. ATIP units within federal institutions are also faced with their own resource challenges. Staff turnover in this field is high. They need additional resources. It is a very difficult sector to work in. And they need the additional resources to deal with the ever-increasing number of requests and to be able to respond to the demand from my own office. So I stress that additional resources are required across the system if Canadians are to be well served by their access to information regime. And if the government is serious about its commitment to transparency, as it is highlighted in ministerial mandate letters, the access to information access system, which play a key role in ensuring government transparency, must be supported and prioritized. Je tiens toutefois à vous assurer.
I want to assure you, however, that the employees at my office are dedicated and are doing amazing things despite limited resources and an ever-expanding workload. They believe in their work and that they do, and I feel very supported. That concludes my opening remarks. I would like to leave you with the message that my door is always open to you and your staff. I'd be pleased to appear before you whenever I am called. And I am very open to meet and engage with you in an individual or group discussions. Access to information is a critical component of openness, transparency, and government accountability. It promotes trust between our institutions and our citizens. Thank you. I'd be pleased to respond to your questions now.
Thank you, Ms. Menard. We will proceed to our first question from Mr. Barrett. You have 6 minutes.
Well, thanks very much, Madam Chair and Ms. Menard. It's a pleasure to meet you. I didn't shake your hand before the meeting because we're not doing that these days, but yeah, an air high five or an elbow bump. So a couple of things that I'd like to discuss with you from your opening comments. And one is the tool that you have for order-making powers. And so, in your words, that was to be able to give an order to an institution to take specific actions, including disclosing more records if you find a complaint to be well-founded. Now, an individual who's testified at this committee in the past, Mr. Vincent Gogolek, who is the former executive director of Freedom of Information and Privacy Association, said, quote, "If someone in government wants a record to disappear, all they have to do is call it a cabinet confidence." And so I expect that, close quote, I expect that you'll see where my question is going. So he goes on to say, quote, "There's no reason to keep this black hole in the Act. Many provincial governments have allowed their information commissioners to examine these records for years without any problem. There isn't any reason the federal government couldn't do the same," close quote. So we've seen from other commissioners, other officers of Parliament, that this has been a hindrance in their work when they've been investigating a well-founded complaint. And I'm just wondering if you can give on the broadly on the subject of cabinet confidences in respect to how you're able to do your work or how you're not able to do your work. If you can give me some context on if that's been a barrier for you.
So in my work, where we see this happening is requests are asking for information, and within the package they receive, there's documents that are blacked out because they are exempted under cabinet confidence. Cabinet confidence currently under the Act are excluded they're not subjected to the Act. So what we do in our investigations, we request the departments to provide certain information to confirm or to make sure that those documents are cabinet confidence. I will agree with you. Canada is one of 3 institutions or level of government where we are not allowed as commissioners to see cabinet confidence. In any other countries, the commissioners are allowed to see that the documents to confirm that they are in fact cabinet confidence. And in some of our investigations in the past, we have been able to conclude that the cabinet confidence stamp has been put on documents that were not, or that so that they should be released. It's not easy to make that determination when you don't see the document. So we would recommend, or I would recommend, at the next review of the Act, that this be amended and that at least we can be able to see those documents.
Right, and thank you for that. What recourse do you have when you have made a determination that the cabinet confidence seal has been misapplied?
Well, if we have come to this conclusion, what we do is we talk to the institutions and we explain why we arrived at those conclusions. In the past, we were only able to make recommendations to the institutions. Now I can order an institutions to disclose a document. So if I was to disagree with the institution, I could result to a final report to the minister explaining why the document is not a cabinet confident. But it's really difficult currently under the current Act because we don't see the documents. So we have to rely on the indexes that are provided by the institution that created the cabinet confidence document, and it's often very difficult to conclude that it's not.
Is there any? Do you publish the metrics or statistics on when you come to that determination that the seal of cabinet confidence has been misapplied to a document during your tenure, your 2 years?
I would say probably it's only happened once.
Okay, so you've noted that funding is obviously essential to do your job. You do a lot with a small but determined team, and so for that, this work is important for Canadians, and so I certainly appreciate your work, as I'm sure we all agree. It's very valuable. How are your resources concentrated to ensure the most number of Canadians receive the best quality of information? So how do you?
Well, currently on a budget of $13 million a year, $11 million is spent on salaries, and 70% of that is all investigation. We have less than 20% of our expenses spent on internal services, corporate services, HR, finance, and then we have a small amount also on legal services and communication outreach. So the majority of my spending is hiring investigators. We currently have, I think, 69 investigators full-time.
Okay, and what is the percentage or proportion of your investigations that are self-initiated versus complaint-driven?
Right now, I've got 2 self-initiating complaints that I've done myself. There are systemic investigations, so that's when we see that an issue seems to be broader than in one file, because you see it in more than one file. I initiated a systemic investigation. I know the former commissioner had initiated a few I don't know how many of them, but we're closing them as it's not much.
Okay.
It's usually because there's an issue that is of public interest and that will have an impact on not just the institutions but on the system overall. That I would do that.
Thank you, ma'am.
Ms. Briere.
Merci pour votre présentation.
Thank you for your presentation. One of the recommendations in the previous Parliament's report was to, in fact, minimise the extent of data and address concerns about the exchange of personal information between the department and government agencies. Have you started to follow up on that recommendation as part of your work? I'm not sure I've understood what you said. Perhaps that question is better directed at the Privacy Commissioner. I work on requests for access to information, but Mr. Terrien, who's a Privacy Commissioner, who you'll be meeting this week or next week, I believe, his mandate is to ensure that there is no, in fact, privacy breach of Canadians or the applicant for so that they can get access to their own information. But as part of my investigations, we do get our hands on personal information which is blacked out, often redacted. We do work closely with Mr. Terrien, but I didn't get wind of what you're referring to. And I'm sure that Mr. Terrien will be able to respond to you. In the same vein, how can an individual be assured that their information isn't being used for purposes other than those for which they gave their consent? Again, Mr. Therrien would be better placed to respond to that question. I'm sure he encounters that in the course of his investigations. What I find frustrating, I should say, is that there might be an ATIP request for information let me give you an example. Someone who applied for refugee status is asked to provide personal information about his wife, his family members, and when he makes a request for information, he's given the information that is of concern to him. And even the information relating to his family and wife is blacked out. So this, of course, entails additional work. The workload is heightened. And I made a recommendation to the Justice Department. The Justice Department is amending the legislation on privacy. So the information should be given to the person who is requesting it rather than having it blacked out. I think that the staff already have enough work laid out for them rather than adding that additional burden. And what are your top priorities for the future, Madam Commissioner? Well, among our top priorities are to reduce the inventory of complaints, to work in collaboration with complainants and institutions to determine what the solutions are aside from proactive disclosure, for example. Oftentimes we ask whether they have an index on the requests for access to information and do they take that into account when they release their documents. There are some countries, after 3 requests, the document is posted on the institution's website. That's not how it works here in Canada. So I encourage institutions to do this themselves. There's no mandatory list here in Canada, but organizations receive on a constant basis these requests, and they themselves should engage in proactive disclosure because that would reduce the workload of our access to information units, which are very small, and unfortunately the number of requests continues to increase. In your presentation, you talked about reducing the inventory of complaints. I imagine that's a substantial challenge for you, given the number of employees you have and the funding that you get. Well, yes, we're trying to get additional funding to be able to hire more staff, but the problem is, in fact, more widespread at a government level. For example, I have 45 new investigators, and I won't be able to get information from my investigators from institutions that are short-staffed too. Oftentimes, these are the same teams that engage in proactive disclosure. They have their own top priority that they need to adhere to. So obviously the request for information is the top priority. They've received information as part of other consultative processes. And that is why sometimes there are longer delays. But it's the same small team that has to manage that side of things as well. That's why it would behoove us to invest more heavily in the system, in IT solutions to do with that system, not just enhancing access to information. And of course, safely. Yes, of course, we want to avoid the kind of breaches you alluded to earlier. So there is a sharing of data between the various government bodies. Well, what I'm referring to, says the Commissioner, is that a document may be disclosed to a person who requested it, and if that document comes from 2 institutions, let me give you an example here. National Defence and Foreign Affairs, Global Affairs. They'll speak to each other to make sure that they're both in agreement about the disclosure of information. So there is a level of consultation and exchange. But when it comes to personal information, that's not usually the case. This is more in the case of public safety, legal opinions, and departments in that case do enter into communication to determine what they can agree on.
Gaudreau for 6 minutes.
Merci de la présentation.
Thank you very much for your presentation. It does shed a lot of light on things, but I'd like to know more. I'd be interested to know about a detail in an example that you gave. So when an access to information request is received, for example, a journalist wants to carry out an investigation, what are the mechanics of that process? How long does it take, given that there is an increase in the number of complaints and you have staffing difficulties? Well, the request for information is the purview of the Treasury Board, but under the legislation, any ATIP request must be responded to within 30 days. And if the individual doesn't get a response within 30 days, they can file a complaint with my office. Institutions can, however, request an extension, and this occurs oftentimes when the number of pages exceeds 500 to 1,000 pages. Institutions in 30 days often won't have enough time to complete the process, or they might have to consult other institutions because they have documents that affect a number of individuals, so they can request an extension. Now, if the individual who's made the request isn't satisfied by the documents they receive or the request for an extension, well, then they can also file another complaint with our office. One of the things that we're seeing with institutions, and it differs from one institution to another. Some institutions have the tools that they need, but in other institutions, there's a paper shuffle. For example, someone receives a request and then they have to physically get up, go and walk over to the office of a colleague, request all documents and emails, and then this is handed to them on paper. This has to be then scanned and redacted by hand. All of that adds to the workload and increases the burden on employees. What we're trying to do is to encourage institutions to invest in software that uses faster technology, cutting-edge technology, a better email management. Oftentimes, well, for example, a Canadian wants to understand how a decision was made regarding a government policy, and the response comprises 10 million pages, 5 million emails, exchanges between officials. But in fact, the 5 individuals who receive the same email are going to submit that very same email. So there's a huge amount of duplication. There's a need to invest and train employees on the management of these files. That would reduce the cost and it would reduce the burden in terms of workload on our employees. And we also have to do the same thing when we carry out our investigation. It's page by page. We have to dialogue with the institution, and this creates a lot of work. Question: with an increase in the number of complaints and the 30-day deadline, is there any correlation with this increase in requests over the past couple of years? You said that the problem is turnover and staffing issues. Well, if you look at the Treasury Board's information over the past 6 years, there's been an increase of over 200% in access to information requests. Last year, the government received over 120,000 requests for access to information. There's an institution that has already, this year alone, received 120,000. ATIP requests have increased by 250%. The complaints continue to mount up in our office, so there is a correlation, and unfortunately the funding hasn't been there to help pick up the slack, so there are holes across the entire system. Have I used all my time, Madam Chair? Excellent. If there was one single recommendation that is crucial, yes, we hear you loud and clear, funding, staffing, but what would be your top priority? There was C38, for example, that was in fact, enacted over the past couple of years. What would be your top recommendation? Well, under the legislation, next year there will be a new legislative review that will take place. My team is looking at each provision of the legislation, going over it with a fine-tooth comb to make sure that our recommendations have to do with the investigations, the complaint filing process, what works, what doesn't work. Unfortunately, there's a difficulty. In fact, there are no time limits set when it comes to institutions communicating with each other. The deadline, as I said, is 30 days. But if you think that, if it's a national security issue or an issue of major import, well, some of the other institutions aren't facing any deadline or time frame to respond to the request from the original institution. So sometimes this drags things out. But unfortunately, the institution that has acknowledged receipt of the request is the one that is subject to the deadline. So I think it's going to be very important in the future to put a deadline on all institutions and individuals to respond to a request for consultation, because this is a problem that is delaying things more and more in terms of access to information requests. Thank you so much. Very informative.
Thank you. Mr. Angus, you have 6 minutes.
Madam Chair. Thank you, Madam, for being here. Your role is vital to our democracy. My former colleague Pat Martin used to say that access to information was the oxygen and lifeblood of the democratic process. And every government that comes in, including this latest one, their first promise is open government. And then the first thing they do when they realize that what's open government is means people can ask questions about bad decisions, they start to try and find all manner of ways to not have open government. So there's a number of tricks. Cabinet confidence. I think that's section 23. No, that's solicitor's client. That's the second one. Solicitor client, cabinet confidence. And then the great one was the great black hole of ministerial offices. Now, that used to drive your former colleague, Commissioner Madame Legault crazy, that how could it be that anything that goes on in a minister's office has to be protected from the public finding out anything, because that's where all the decisions are made. Under Bill C-58, did any of that change?
Under Bill C-58, there's Part 2 now, the proactive disclosure. So what they've done is they codified basically the policy that existed before on proactive disclosure, and it is also applied to a number of new institutions, including the minister's office, the Senate, the judges.
Oh, the Senate, yes.
So the proactive disclosure is one way to open up, and it was something that was added. But there's a difference between my role, which is under Part 1 to investigate access requests. The Part 2, which is proactive disclosure, is outside of my mandate. One thing also that was added, and I thought I was going to be happy with this, but they added the name of the staffers of ministers' offices and their title are not anymore considered private information, personal information. The problem is they're not considered like public service still. So all you can receive is the name of the staff and their title. But if there's other information related to that person, they're not considered like a pure public servant, which the information of a public servant under the Privacy Act, if you're not aware, their name, their title, their opinion, anything related to work and what's related to the business is not considered personal information. So they've made a difference between the two.
Well, there's a difference between proactive disclosure and right to access documents. And I would refer my colleagues back to 2011 when Tony Clement managed to get $50 million in border security money diverted to Muskoka to spend money on gazebos and sunken boats. And all that was under ministerial privilege. And we couldn't find out how he spent a dime until we went to the municipalities, where, thanks to their Access to Information Act, we found they had homemade applications for spending money and that's how that got out. But if it was under the minister's office, we knew nothing. So, is making sure that we have access, or at least giving you the right to decide? I think that's the fundamental question. I can't say if it's cabinet confidence. You can. it seems to me that it's interfering with your work if you don't have the right to decide whether or not those documents do fall under that or they're just being needlessly protected.
I agree. I think that it should be like the solicitor-client privilege is one of the most protected privilege, and but I still entitled to see the document. And I can tell you, Canadians trust when somebody who is not the institution. If we have a document in front of us and we tell the person, yes, what you receive is blacked out, that it's redacted because it's a legal opinion or it's protected by Section 23, like you say. It reassures Canadians, and I think the same thing would happen with cabinet confidence. If we were to be able to confirm, to see it, and not release, we don't release documents. We would never ourselves give disclosure to a document. We then talk to the institutions and ask them to release or make an order, and if they don't agree with my order or my recommendations, they can go to court, and there's nothing disclosed until a final decision is made.
Okay, well, let's talk about that, because in 2014, I asked the government, which was then the Conservative government, for notes regarding the decision, the political decision, to withhold the 10,000 pages of police evidence of the crimes that were committed against children at St. Anne's Residential School. I was not looking for those police documents. I don't have a right to them. I was asking for the emails, the political decision that went into that act, which should have been covered. It was delayed, and then the Liberals came in and then just said, no, we're not going to let you see them at all. Your predecessor took them on. We spent many years. In fact, she threatened to take them to court. They agreed finally to give me the documents in 3 batches. I'll bring them in if people want to see them. 3 batches of blacked out documents of every email saying, hey, Mary, how's it going? Blacked out. Hey, Bob, blacked out. So it strikes me as if the Justice Department just waits out. I mean, it was 7 years we fought this battle. They were threatened with going to federal court, and they still blacked out to protect the minister. With your order-making powers, could you have changed that decision, or do they have that power to just defy and not turn over documents that should be within the public realm?
Well,
You have 20 seconds.
I can order production of documents, except for the cabinet confidence, but I can also, yes, if I make an order that the disclosure should be done or that exemptions should not be applied, it's now the onus is on the institution to go to court, not on me to fight the decision.
Okay, thank you.
Thank you. Continuing on for the 5-minute rounds, we're going to Mr. Gord.
Thank you very much, Madam Chair. Thank you, Commissioner. You touched on an issue earlier, good practices in other countries that aren't used here. If we compare Canada with other countries, maybe we're happy to be here in Canada, but are there countries that have access to information practices that are worthy of being emulated here in Canada? Response. Our legislation has existed for 36 years. We were the 12th nation in the world to have an Access to Information Act. So we were pioneers in this sense. There are now 120 countries that have Access to Information Acts. And of course, some are brand new. And some give more power, and others more extensions. Our legislation could be overhauled and enhanced, but we need to see how things are put into practice in other countries. Now, for example, there are nations that are very liberal in terms of access to information. And in Canada, our government seems to be very understanding when it comes to extensions or exemptions. Now, when it comes time to propose legislative amendments, we look at what other jurisdictions are doing in Canada. Each and every province and territory has its own information commissioner and its own legislation. And often the provinces and territories will share their best practices with us at a federal level. And we also look at other countries. For example, there are countries where after 3 requests for information, the information is automatically released and published, and that country is Australia. Now, that's one of the constraints we have in Canada. that isn't the case elsewhere. Oftentimes, we're criticised for the fact that we'd like to give more information, but the fact that the information has to be provided in both official languages takes longer and costs more. So we're trying to find remedies to that problem. Can we provide access aside from just publishing information? Can we provide summaries, for example? But obviously Canadians are entitled to receive information in both official languages. And when it is an access to information request, they'll receive the information, the documentation in the language of the request. So, of course, there are always limits to being in a bilingual country. You said that there was a huge increase in the number of complaints. Do you have a sense of what that is due to? This is quite new, this 220% increase. You said 20% increase annually. That's a lot, isn't it? Well, one of the theories is that now I have an order-making authority, and increasingly Canadians are fed up with waiting. They become impatient. There are so many complaints that are submitted to our office, individuals who've waited months, even years, to get their hands on the information they've requested. And now that Canadians know that I have an order-making authority to order an institution to provide and process information, well, Canadians are aware of this. We haven't seen a huge increase, however, in terms of complaints regarding extensions. Or, for example, when the complainant complains of not having received the fulsomeness of the information, and the figures are similar in that respect too. This year, there are 4,000 complaints that were filed against one institution, which all have to do with processing delays. That institution received 120,000 requests, access requests. Obviously, we're going to receive complaints because the increase in access requests is so high that these institutions just cannot respond within 30 days, and that is a really big problem. Do you need to make an ATIP request to know which institutions you're talking about? Because if Canadians are disadvantaged, they would want to share that kind of information with other Canadians. Response: well, when I see that there is a broad-based, widespread problem like that, as I said earlier, I have the authority to initiate an investigation, and I did so. I initiated a systemic investigation of Citizenship and Immigration Canada. They have received a huge number of requests. They are working very hard. And oftentimes, in the space of time where we receive the complaint, they've already responded to the request. But what we're trying to ascertain is why there are so many requests, what the nature of those requests are, what the challenges are, and how we can help these institutions. We can't manage 5,000 additional requests each year. Just a bit of advice, if I may.
Moving on then to Ms. Shanahan for 5 minutes.
Merci beaucoup, justement, Madame.
Thank you very much, Madam Commissioner. I'm just trying to get a handle on this, a bit like my colleague Mr. Gord, of the scope of your work. If I've understood correctly, has everyone received this inventory? It's very practical. It's got some pie charts on it. And you'll tell me why this only goes back to 2018. But if we were to rely on these figures, well, obviously there's an increase from year to year. Unless the backlog is completely wiped out, well, there's always going to be a backlog for a whole host of reasons that you alluded to earlier. Now, am I right in saying, and you referred to about 2,000 out of a total of 120,000 access requests? It's about 1 and 2%, between 1 and 2%? 4,000? Well, could you just elaborate on the table? I'm just trying to understand if it's about 1 or 2% of the total number of requests and complaints. Well, fewer than 3% of complaints are being filed, that is, in comparison to the access requests. So it's a very small complaint rate, if you put it into perspective. Now, this table indicates that when I was appointed Commissioner in 2018, there was 3,489 files in the inventory. So that was my starting point when I was appointed. 3,489 active complaints under investigation. As of the 1st of April 2019, and this is a year-by-year analysis after 1 year of work, this dropped down to 3,345. But what's in grey there is what remained from the original inventory, and the purple-pink are the new requests. And then, as you can see from 2020, we've again gotten rid of a lot of the backlog. We're still working on some of last year's requests. Given that we received over 5,900 new complaints, well, we still have a lot left to process this year. So all of that to say, and this morning we had completed I checked, we'd completed 5,200 complaints. This was unprecedented. Last year it was about 2,600, the year before 2,400, and we are able to address most of complaints with an informal resolution. However, we'll never be able to meet this increasing demand with the resources that we have at our disposal. Well, that's very interesting, Madam Commissioner. And what are the options in terms of complaints? Either the complaint is not well-founded, or the second option is, well, the complaint is well-founded but can be easily resolved. Or thirdly, the complaint is well-founded but requires a more formal complaint resolution process. Well, what I can tell you is that institutions understand what our challenges are and are ready and willing to cooperate with us. We are constantly communicating with these institutions. We speak to the complainant about them, and if we can't reach agreement, well, then that's life. That's my job. I just say, well, listen, this is the legislation. You haven't followed the law, and I'm going to make a recommendation or issue an order, and then at that point we determine whether it needs to go to court. Unfortunately, last year, given the amendments to the legislation, it was the first time we were allowed to release the reports of our investigations. So there are 35 years of precedents of complaints that were settled, that were investigated, and yet there is no information that was published or shared except by way of the annual reports. And that's something that was very frustrating to me. When I applied for this position, well, obviously, I looked for information on the institution where I'd be working, or hopefully working. There was no information about the number of decisions as a result of investigations. So what we've decided to start doing is provide summaries of the decisions so that, for example, if there's a decision in a national defence file, well, there'll be a summary and that Canadians can rely on. And we're starting to publish guidelines as well. But here, we've had this authority since June only.
I'm on that.
Okay.
Sorry.
Très intéressant. J'espère que ça va continuer.
Mr. Carrick, you have 5 minutes.
Thank you very much, Madam Chair, and thank you, Commissioner, for coming and sharing about your office and the important work that you do. So help me a little bit here. I've made ATIP requests before, and I've been involved with receiving them, and I've always found the process to be quite good. But I've always wondered about those documents, between a word that was spelt wrong or some document gets missed. What procedures and protocols do you have in place to ensure that those documents that might be vital to access a request don't fall through the cracks?
So we call those investigations of no record,
Sure.
because you will receive a document and something is missing, or often the applicants will say there should be something more. So we will ask the institutions what search was done, what are the words that were searched, where were they done, who did them, who was tasked with finding those records. And sometimes we find it's either an analyst that was a junior analyst that didn't task the right person. We often find them, and when we don't find them, and it should be something, like I think the former commissioner issued a report at one point when a very crucial decision was made by a federal institution, and there was no record, just a decision. Right. So clearly there was a lack of recording, and we don't have currently we have a policy on a business record, so you're supposed to keep record of your decisions and how you make them, but it's not legislated. So it's really difficult to manage that. I think it should be something that would be imposing on institutions like we do for financial expenditure. We have to have the evidence that we searched for the best reasonable, travel arrangement, let's say, and then we have a control in place to make sure that the authority are signing it. It should be the same thing for very important business decisions. There should be a mandatory recording of those.
Okay.
Yeah.
Thank you. That's always been a question, and because I have the commissioner in front of me, I appreciate the opportunity to ask. Now we live in a world where certainly it wasn't that many years ago when the primary forms of communications were letters and phone calls, and then letters and emails, and now text messages, WhatsApp, other secure messaging services. I know that there's a tremendous variety of ways that people communicate with each other, and although certainly there's a understanding within a professional workplace that there are reasonable ways to communicate back and forth. What steps has your office and investigators and what tools do they have to make sure that text messages, WhatsApp messages are covered in this? Because sometimes that gap can be very much the fact that it went from an email chain to a text message chain, and then went back to email after a decision might have been made over a text message.
It's difficult. The former commissioner issued a report on this as well, and I agree with her. Those apps should not be used for government businesses. And we emphasize that when we meet with public servants, when we meet with their leaders, with deputy ministers, but it's really difficult to know when it is used or not, and often it's by mistake that we find out. So if we see evidence that something others than emails and or personal emails, that's another one, we will push and we will get the information. And again, I have all kinds of tools. I'll order the productions of tapes. I can order the productions of documents. So I can ask and that they research these texts and these other apps, but it's very, again, it's one of those things that we're lucky or we're not, and we hope that the government is implementing their policy of not using these apps for a business record.
And I think that this will increasingly become an issue as for example, each of us around this table have Facebook pages, right? And that's where it's, a Facebook page, it's owned by myself, but it's used for parliamentary purposes, and there's an ambiguity in even ownership of that information and its different uses. So I appreciate that, and I know that I'm sure there will be lots more work done in that regard.
Mr. Keurig, I'm sorry, that's your time.
That's all. It went so quickly. Thank you very much. I had so many more good questions.
Mr. Fergus will be our last individual asking questions for 5 minutes.
Tout d'abord, merci beaucoup à Ménard.
To begin with, thank you very much, Madam Ménard, for your presentation, and thank you for your service as Commissioner for Access to Information. My questions will tie in with Mr. Gord's and Ms. Zanahan's questions regarding the complaints that you have received and the huge rise in the number of complaints, an unbelievable increase in just the space of 1 year. Could you please in fact, flesh out what the nature of these complaints actually was. Could you put a bit of meat on the bones in that respect? As I said earlier, most of the complaints are regarding administrative matters. For example, complaints about delays, extensions that have been requested that the complainants deem to be too long, or where the institution missed the deadline, the 30-day deadline. They didn't provide a valid reason or even send in a letter, and therefore the complainant will further complain and inquiring as to why the ATIP request wasn't responded to within the 30-day legislated timeframe, the statutory timeframe. Now, we've received 4,900 administrative complaints of that nature this year. The rest of the complaints are about extensions. These are where refusal was issued by relying on a number of provisions of the legislation. So we determine whether the Act was adhered to regarding those matters and whether additional clarification or justification should have been provided. Fewer files like that, but they're often more difficult to process. But that begs a question. Are the institutions obligated to inform you that they're seeking an extension? Well, first we ask them why they didn't meet the deadline, and usually they immediately come back with the number of pages that they've been asked to provide, the depth and breadth of the consultative process, how many institutions they have to consult, the archives that they need to delve into. They're the kinds of reasons that they use as arguments as to why their deadlines weren't met. Question: Do you and your colleagues in your office are you more or less satisfied with these, generally speaking, with the legitimacy, in terms of the legitimacy of these requests for an extension? Half the time? Two-thirds of the time? Well, it's difficult to say. Some institutions, for example, Citizenship and Immigration Canada, will provide the information within a certain time frame, but they might miss the deadline by 15 or 20 days. But given the number of requests that they receive, which is incredible, they are doing pretty well. They have a big team, and often these requests aren't for huge numbers of pages, usually about 1,000 pages, but then there are other institutions that get a lot of complaints in excess of 1,000 pages. Now, as I said earlier, when we observe a more systemic problem, well, we start by bringing the issue up to with the Deputy Minister. Often the Deputy Minister in question isn't even aware of the access to information issue at hand. When the Deputy Minister asks for information, they want all the data be there, and others would prefer that it be flagged on their behalf. But I just don't wait. I intervene, and I tell the Deputy Minister in question what our challenges are with the institution in question, what can be done better. And oftentimes, these delays are due to a lack of resources and poor human resources management. They're the kind of things that come up over and over again. Question: when departments really blow a hole in their deadlines, well, what they have to do, they have to make a request for an extension. So within that 30-day time period, they assess the request, and then they come back to us and say, we just cannot meet this 30-day deadline, and we give them a 30 or 60-day extension. I recently, for a file of 70,000 pages, we were asked for an extremely long extension. 75 million pages. 75 million pages. Well, I still haven't finished my investigation, but that is within my purview, yes.
I want to thank you very much, Ms. Menard, for coming today and for being so obliging in terms of your opening statement, and then, of course, taking questions from the members around the table. We certainly do appreciate your participation here today, so thank you.
Thank you very much. Merci beaucoup.
With that, for the next round, we do move in camera, so I would ask that we would take the next 2 minutes and clear the room as quickly as possible. Thank you. And I will suspend.
Thank you.